Thank you so much. We are going to get started. I'm very, very pleased to present our two presenters today. We have Ian Henderson, who's the Director of Legal and Systems at the Wisconsin Coalition Against Sexual Assault. We're also going to have Sarah Finger joining us, who is the Executive Director of the Wisconsin Alliance for Women's Health. With that being said, I'm going to hand it over to Ian. Thanks again so much for joining us. If you have any questions, you can put it in the chat. We'll try to address any technical or other sorts of difficulties that you might be experiencing. Thanks so much.
Thanks, Rose, and welcome everyone to the webinar series. I'm happy to be talking to you all today. What we're going to be doing, Rose introduced myself, and our guest speaker, Sarah Finger, is going through a summary of the 2013-14 legislative session. So we're going to talk a little bit about not only WCASA's advocacy and our priorities going into that session, but also some of the key sexual assault-related legislation that was passed as a result or as a product of that session, and then talk a little bit about next steps and looking forward to the session coming up. And then we're going to turn it over to Sarah, who's going to talk about the Alliance's Ask, Learn, Vote campaign. And then I'm going to have ask Sarah to jump in at a critical point or points as we go through the summary. And we'll just kind of do this as a informal presentation. And if people have questions, certainly feel free to note that on the chat. But we're gonna get started. And so thinking back to the session, it's hard to think about really 2 years ago at this time, us looking forward to the budget advocacy and particularly funding for the Sexual Assault Victim Services Program, or the SAVES program, which funds it's the state funding for sexual assault services in Wisconsin. But that has been a priority of WCASA's, as I'm sure you all know, for many years. And you probably are aware or remember that it's had a fairly tumultuous history in the recent years. Looking back to about 3 years ago, the way the SAVES program was funded prior to the session, which was through the Crime Victim Witness Surcharge, which is really fees that are collected from criminal defendants, go into a sort of pot of money, and then part of that money was used to fund different programs, one of them being the SAVES program. Well, that source of revenue we were concerned of not being terribly stable, and in fact we saw 3 years ago as the revenues coming into that program declined, the need to reduce the SAVES allocations pretty substantially, and you may all remember that. So that, one of the things WCASA has been working on for several years is trying to stabilize that funding source, and by doing that, by moving the funding structure out of the surcharge and into the use of general purpose revenue or state tax dollars, which is much more stable source of funding for the SAVES program. And so that had been a priority for some time, and those events of 3 years ago sort of just highlighted the need for that, and obviously there was a fair amount of attention directed towards what happened with SAVES. And then so we saw in the last budget cycle the Attorney General putting in his budget request, simplifying the funding structure, which was a huge first step, and then the governor, when he released his budget, restoring SAVES to its previous high of $2 million per year, and in doing that by using GPR, or general purpose revenue, for the first time in state history. And so that budget and that provision of the budget obviously sailed through really without much controversy, which was great. And so we saw a huge success early on in the session with that budget advocacy, with the governor releasing his budget and then that making it through the joint finance process and passing the legislature and being signed by the governor. So that we saw this significant commitment to sexual assault services in Wisconsin and to funding sexual assault services, and doing so in a way that really stabilizes the program and hopefully paves the way for increasing that funding source and funding for sexual assault services in future years. And as I mentioned at the beginning, we'll talk a little bit about priorities going forward. So that again, happened early on in the session, and one of the things we saw was early success in this session. And WCASA's other, or one of our other main priorities, not related to the budget, so non-fiscal priorities, was related to advocacy. And so many of you are probably familiar with what we were calling the victim accompaniment legislation. And that legislation is something that has been a priority of WCASA's for many years, really dating back to when I first started at WCASA 7 years ago. This concept and the idea behind this type of legislation was in the developing stages. And so it's something we've been working on since that time. And I'll just do a brief overview of what accompaniment is. I'm sure many of you are aware, but victim accompaniment grants victims of sexual assault the right to be accompanied by a victim advocate at key stages of the process, of the criminal justice process or the healthcare process. That legislation really guarantees that emotional support, that information, and all the valuable services that advocates provide are available to victims of sexual assault after an assault. And I think, I'm probably preaching to the choir as to why that's important. But it's been something that we've been working on really for a lengthy time. And so what does that do? It basically states that at the victim's request, an advocate may attend any exam or consultation at a hospital, so we would be thinking of SANE exam or also any criminal justice proceeding, which would include law enforcement interviews or would include meetings with prosecutors. So that's just a quick overview of accompaniment. And that particular right was, for the criminal justice piece, was housed in Chapter 950, which is where the crime victim rights laws are found. And so that would codify that and make that a right of crime victims to have that advocate present. And it would also include, as I mentioned, exams or consultations at hospitals, so thinking of the SANE exam or medical proceedings. Why do we need this? And I think one of the things we looked at as far as putting out proactively why we think this is so beneficial would be a belief, and really supported by data, of improved outcomes in both the healthcare and criminal justice systems for victims and for those systems when sexual assault victims have a community-based advocate present with them. That not only are those systems less re-victimizing, but that we see, in fact, better outcomes for victims. And that, I mentioned data supporting that, comes from an article by Rebecca Campbell at Michigan State University. If any of you are interested, you can email me, and I can provide you that article. But really, she did a study that really can show that, in addition to the anecdotal evidence or the anecdotal information we can provide from survivors who can talk about their experiences of having an advocate, and conversely, what it was like to go through that system alone if they didn't have an advocate. We have some data and some support or scientific support, social science support for that principle. The other question that we often get around this law would be, do other states have similar legislation? And in fact, our research says yes, they do. 11 other states have legislation, and in the District of Columbia, just earlier this year, passed similar legislation. And those laws vary slightly, but generally allow that advocacy presence at those key proceedings. So what happened this session with accompaniment? Well, again, early on in the session, so early in the spring of 2013, the legislation was drafted and ready to go. It was introduced with widespread bipartisan support, and we kind of spent the summer gearing up for hearings to be held in the relevant chambers and in the committees that the bill was assigned to. And we did become aware of, in the summer, some concerns about the legislation and concerns about maybe how expansive it was, concerns related to what happens if an advocate isn't available to attend the proceeding or the SANE exam, for example, or the law enforcement interview, and what happens if there aren't services in those communities. We were aware of that and began moving forward to looking forward to hearings being held in the Senate and the Assembly. So I mentioned some of the concerns that were raised, and then we met with the Hospitals Association, who had expressed some of those concerns to try and work on a compromise language regarding accompaniment, and to address some of the issues that they had. So trying to limit the focus of the originally accompaniment included all domestic violence, sexual assault, stalking, and we narrowed that focus to sexual assault due to some of those concerns. And then a hearing was held in the Senate committee, and we met with representatives of the Department of Justice and worked really hard on some compromise language that would not contain everything we wanted, but was really a meeting in the middle, and we were really pleased with those efforts. And some of the other states have language in their accompaniment proceedings or accompaniment law that allows either the hospital or hospital officials or law enforcement to exclude an advocate if that presence would be disruptive. And so, through those negotiations, through that compromise, that amended legislation did have some of that opt-out language. But we tried to craft the exceptions really narrowly to make sure that that right was a meaningful right. And that version passed out of the Senate committee, which was a really positive development. But, by the time this all happened, we were getting late in the session, and there was not action by the full Senate or the Assembly committee. So, we can look at this as the temptation would be to look at this as a negative, but I think while we didn't get it passed, and obviously that was our goal this session, we had immense progress. And I think by meeting with the relevant parties and working on language to really make this the best legislation we can and to address those concerns that were out there, I think we're set up nicely for the next session. And although it didn't pass this time, we're committed to working on this in the future. And so I think you'll likely see efforts related to accompaniment put forth by WCASA in the future. So now I'm going to shift gears from kind of our proactive legislative agenda to talk about some of the priorities or some of the legislation that was passed and enacted this session that relates to sexual assault and that relates to victims of sexual assault. And one of the key areas and one of the areas we saw really fairly comprehensive changes and some really positive developments relates to human trafficking. This subject area is of concern by not only the legislature, and the Attorney General has made it a priority of his to address and combat human trafficking, that we saw fairly comprehensive legislation looking at human trafficking and looking at modifying the existing statutes related to trafficking. And so I'm going to talk a little bit about those provisions, and we'll see as we go forward how that legislation also had some significant changes related to sexual assault victims beyond trafficking victims. So the act that I'm referencing is Act 362. So for those of you who, all of these are available online on the Wisconsin Legislature's homepage. I also have copies of them and would be happy to share those documents if any of you are interested in looking at the acts themselves or the Legislative Council's documents that provide a summary, which are really helpful of these acts. Again, please feel free. You can find them online or contact me, and I'd be happy to share those with you. So Act 362, one of the key changes made to the human trafficking statute regards the element that was in the law when it was passed several years ago that said trafficking is completed by recruiting, harboring, or enticing an individual without their consent for the purposes of trafficking them, which is defined as a commercial sex act or labor services. And so this legislation took out that, or removes the without the individual's consent element from the definition of trafficking. I think why that's significant, if you think about it, is it sort of implies that someone, could consent to being trafficked. If you have without the consent element, think about how that operates in our sexual assault laws. It operates that oftentimes the defense is, well, it was consensual. Well, this law, Act 362, takes that consent element out. So now it basically talks about trafficking is recruiting, harboring, or enticing someone for the purposes of either labor services or a commercial sex act, and that without the consent element is absent. And I think that's a real positive step, acknowledging that really people aren't consenting to being trafficked. The other piece that this law does, it expands the commercial sex act definition, and that's, again, one of the key, in addition to the labor services, commercial sex acts are the other core definition of human trafficking. And that definition now includes not only sexual contact, which was how it was defined previously, but includes sexual intercourse, sexually explicit performance, or any other conduct that's done for the purposes of sexual arousal or gratification or degradation or humiliation. And again, that those things are done for which anything of value is either given, promised, or received, right? So Commercial Sex Act now includes all these things for which anything of value is given, promised, or received. So it's a more expansive definition. Act 362 also expands the list of prohibited conduct to include trafficking that is done by threatening to control access to controlled substances. So I think, again, this legislation is recognizing that trafficking can be completed by various tactics and strategies, and that one of those may be using someone's addiction to a controlled substance as a way of keeping them involved in prostitution, labor services, etc., and so prohibiting and looking at trafficking that is based on keeping someone under that person's control by, controlling their access to a controlled substance. The second bullet point about using a scheme or pattern to coerce or threaten to intimidate, that basically simplifies that definition to basically talk about really any pattern or scheme that is used to intimidate someone into being trafficked, as opposed to the previous more cumbersome definition that talked about causing an individual to believe any other individual except for bodily or financially harm. So again, I think the important thing here is a simplification, trying to make the statute usable by prosecutors so that offenders can be held accountable, and we are certainly seeing that happening. It also adds the use or threat of force or violence, or the even broader kind of catch-all category of causing or threatening to cause any person to do anything against their will or without their consent. And that last bullet point, again, was added by Act 362. In terms of looking at offenders and perpetrators and trying to more actively capture or hold accountable those people who are benefiting from trafficking or participating in trafficking, trafficking now includes knowingly receiving compensation from either debt bondage or a commercial sex act. Prior to Act 362, that type of knowingly receiving compensation from a commercial sex act was really found under the pandering statute, which was a Class A misdemeanor. So now we are looking at trying to hold accountable those people who are benefiting from trafficking, so who are knowing that they're getting compensation from prostitution, that is now encompassed in the human trafficking definition and is now, as a result, a felony as opposed to a Class A misdemeanor. In terms of looking at victims of human trafficking, Act 362 makes some important steps to try and look at treating victims of trafficking as victims and not as victims and perhaps also people who are criminals. And particularly when you think of prostitutes, obviously prostitution is a crime in Wisconsin as it is everywhere. And so this law creates a procedure where victims of trafficking, victims of commercial sex act trafficking, can request a court to vacate a conviction or expunge their record for prostitution. And so this statute lays out a very specific procedure for expunging or vacating those convictions. Again, starting to look at treating victims as victims and not as criminals as well, which I think is an important way to start trying to offer services and to acknowledge the impact that this crime has on victims. Act 362 also made changes to some of the other sexual assault laws, as I mentioned, that are not specific to trafficking. And with regard to some crimes against children, the crimes of child enticement and exposing genitals to a child now prohibit the exposure of intimate parts. What I think you're seeing with these parts of the Act are ways to just simplify some of the definitions and the terms that are used in some of these crimes against children. So enticement used to have the phrase exposing a sex organ, which again was not a phrase that was found really in any other statute. So this crime now uses genitals, pubic area, intimate parts, which is language that is more harmonious with other crimes. Again, trying to reduce any confusion or just kind of simplify these crimes and how prosecutors are able to utilize them by removing confusion. And the exposing genitals or pubic area was a former and is still a crime, but it now adds intimate parts as an element, which again has a specific definition in the statutes. Act 362 also made some changes related to strangulation. And specifically it added that crime of strangulation to the list of crimes for which a victim may apply for crime victim compensation. Again, certainly a positive development. And it also added strangulation to the definition of domestic abuse for the purpose of keeping that victim's information confidential in voting documents. And one of the other really, I think, significant changes that Act 362 contains related to prosecuting sexual assault. And again, this is beyond just trafficking cases. You all may be familiar with something that's termed other acts evidence utilized in the prosecutions. And other acts evidence is basically evidence that can be used of sort of other misconduct or other crimes or other bad acts that are utilized in the prosecution of an offender, a sexual assault offender, bringing in evidence of prior assaults. Generally speaking, the rule in our criminal law states that, you can't use other bad acts to show it's more likely that the person did the current crime or committed the current crime. That's kind of a general principle in our criminal law. However, there is this provision that allows this other acts type of evidence to be utilized, providing the prosecutor, can follow the specific procedures outlined in our statute and in cases that interpret the statute. Well, what this statute does, or what Act 362 does, is states that other acts evidence may be admissible without regard to whether the victim of the crime is the same as the victim in the similar act in the following cases. And you can see the list there: human trafficking, any crime against a child, serious sex offenses would include first through third degree sexual assault under Chapter 940, and domestic abuse. So really what this is doing is saying that in those crimes or in those prosecutions, other acts evidence will be, allowed with a greater latitude, basically. DAs and prosecutors still have to go through their, have to meet their required provisions under the law of getting this evidence in, But this law basically states that, this type of evidence should be allowed with greater latitude, particularly, and maybe whether the victim of the crime is the same is really not dispositive in whether or not the evidence should be allowed. Lastly, Act 362 makes some changes regarding sex offenders and which offenders are subject to lifetime supervision. It now states, and this is a nice segue for our next topic, it states that certain crimes against privacy, and what we're talking about there would be the crime of invasion of privacy, which would be kind of your peeping Tom statute, or capturing an image of nudity, that those offenders may be subject to lifetime supervision if the court can determine the conduct was done for the offender's sexual arousal or gratification. Which brings us to the next area of legislation passed in this session, really looking at those crimes of capturing an image of nudity. They kind of more colloquially had the term revenge porn statute, and we saw an effort to pass legislation related to these type of crimes in this particular session. I think we'll also likely see further efforts regarding this type of offense and offenders in future legislative sessions. And I'll talk a little more about that, too, as we go forward. So Act 243 creates a new crime to address revenge porn crimes. And what we mean really, what that term encompasses would be oftentimes it may be a consensual recording or capturing or taking a picture of either nudity or sexually explicit conduct where the actual image was created and done so consensually, but the posting is done non-consensually, so that the revenge porn being the individuals were maybe in a relationship of some sort, and after that relationship ends, then the person posts nude or sexually explicit images of the victim on the internet. And so these new crimes are Class A misdemeanors. And I think, we could have a philosophical conversation about whether we think that's an appropriate sanction for this. I think and having heard from survivors of this particular crime, I will tell you that, what they express is that the level of trauma and betrayal and just complete feeling of exposure by posting these types of images is really significant. So it may be that something that needs to be looked at in the future would be whether or not we think the sanctions are appropriate. But I think, again, I think that's something that we can look at down the road. So what Act 243 does is looking at the crime that was previously and is still currently called capturing an image of nudity, and it creates this definition of a term called a private representation. And what is a private representation? Well, you can see the definition there, that it's a photo, it's a video that either depicts a nude or partially nude person, or depicts or shows a person engaging in sexually explicit conduct. And of course that has a meaning in the statute, sexually explicit conduct, which would include sexual intercourse, masturbation, or exhibition of intimate parts. And so this crime now includes that posting a private representation is a Class A misdemeanor if the actor, the poster, knows that the person depicted in the image does not consent to the posting. So again, recognizing that the image may have been captured consensually. We already have crimes to deal with the non-consensual capturing of those images, but images that are created or captured consensually but posted without consent are now subject to this act. It also includes posting a depiction of someone that the actor knows is a private image without the consent of that person. So kind of capturing even that reposting of images. So not only the person who created the image or captured the image and then posted it, but someone who may post that image that they know to be a private image without the consent of the person depicted is now subject to Chapter 942.09, the capturing an image of nudity statute, and subject to a Class A misdemeanor. Are there gaps in the current law? I think there may be, and I think we've heard others talk about, and there was a session at the conference last fall that had survivors come and talk about it, that, other behavior that we see would be, capturing an image where there isn't nudity. So that might be termed upskirting, people who take pictures up the skirts of people who are in public, but that it's not nudity, and posting those. Audio recordings is another area that may be ripe for expansion. And then looking at making sure that the focus isn't specifically so focused on nudity, that there may be images that are private, that people wouldn't want posted, that are not so focused on nudity or sexually explicit conduct. So I think, again, an area where we're likely to see further legislation, and as technology changes, I think there's an effort to make sure that our laws are meeting the current state of technology. And so I think stay tuned on that front as well. Shifting gears a bit now to allowing victims whose offenders are convicted, particularly those convicted of felony sexual assaults, access to what's termed the pre-sentence investigation report. For many individuals convicted of felonies in Wisconsin, the court may order a pre-sentence investigation report to be completed. Sort of requires DOC to prepare that report and to aid the court in sentencing the offender. Generally speaking, only prosecutors and defense counsel were entitled to copies of that PSI, the pre-sentence investigation report. Act 338 broadens that to now allow victims access to certain portions of that PSI, and those portions would include sentencing recommendations, as well as any information related to pertaining to the victim. So again, right, the victim could see not only the sentencing recommendation, but any information pertaining to the victim. However, so I think from a general perspective, that's a really positive development. And when the legislators who were thinking about this legislation, they reached out to WCASA, as a rule, I think providing victims more information is never a bad thing, particularly as it relates to potential consequences for the offenders. The only piece that that there's some, I don't know about concern, or that we express some question about would be, it states that the victim can't keep a copy of the report, which doesn't seem to be an issue, but that they must keep the information confidential. And so, what happens if the PSI contains a recommendation that is disappointing to the victim, or has information about the victim that they have questions about, or are, I think, so how can victims process that? And it would seem to be true that they could certainly reach out to DOC and prosecutors and others who have access to that as well, but what about community-based advocacy? And I think that remains a question about, the law does say the victim must keep the information confidential. But again, I think as a whole, this is a really positive piece of legislation. Again, giving victims more information as a rule, I think, is always a positive. Next area of changes we're going to look at relate to housing. And we saw some developments relating to housing law and sexual assault and domestic abuse in this session. This was part of legislation that I think had provisions that were certainly not necessarily tenant-friendly. It seemed, one of the sort of philosophies of this particular act as a whole, Act 76, was to kind of strengthen the rights of landlords. But within that legislation, it had some pretty significant provisions related to sexual assault. And that basically says that leases are void and unenforceable if they have provisions that allow a landlord to terminate a tenancy based on the commission of a crime in or near the rental property, and that they are void if the tenant is a victim of that crime. So, and that kind of replaced a provision under prior law which said landlords can terminate a tenancy if a crime is committed on or near the property, and without regard to whether the victim could have prevented that crime. So this, narrows those provisions and says if the tenant is a victim, you cannot terminate solely based on the commission of a crime in or on the rental property, and that leases that contain provisions such as those are not enforceable. Again, a positive step for sexual assault and domestic abuse victims. It also required lease to include specific notices of sexual assault and domestic abuse protections, and that those notices include that victims may have a defense to an eviction based on their status as of a victim of sexual assault, if the landlord should have known that or knew that, and that the eviction is related to their to the victimization, to the sexual assault, and that victims also may have a right to terminate their tenancy. And we've talked about those laws in the past, and on our website you have an information sheet that really summarizes all the housing law provisions related to sexual assault and domestic abuse victims. So please check our website for that fact sheet. It's up to date and contains the information contained in Act 76. In addition to requiring that notice, it says that a lease was not enforceable if it allows a landlord to terminate a tenancy for a criminal activity and does not have that notice. So I think, again, providing notice to victims and obviously people who are signing leases can, that this notice contains those rights. There were also really significant changes related to restraining orders and injunctions in Wisconsin. I'm going to just touch very briefly on some of these. I would encourage you to contact End Abuse Wisconsin, the organization formerly known as WCASA. Tony and Tess there would be available, I'm sure, to talk to you with more detailed questions. Obviously, End Abuse worked really hard on many of these changes, and I'm just going to cover them very, very briefly. I just want to alert you to some of the highlights. But again, for more information, I would refer you over to End Abuse. Act 311 contains provisions that talk about how long an injunction may be in place. Under prior law, the standard was basically 4 years was the maximum for most injunctions except child abuse. And Act 311 says the court may actually extend that or issue that for 10 years, or which would be 5 in the case of a child abuse injunction. So 10 years would be for domestic abuse, harassment, or individuals at risk. However, the court, to do that, the court must find by a preponderance of the evidence that there's a substantial risk that the defendant may commit first or third degree sexual assault or first or second degree child sexual assault. It would also include first or second degree intentional homicide. So again, there's a fairly high showing there that would be required before a court could issue or extend that injunction for up to 10 years. But just want to alert you to that those provisions exist, and there is that possibility. Act 322 again would be something that you probably are aware of. End Abuse worked really hard on this particular piece of legislation. So for more information, again, please contact them. But Act 322 talked about the firearm surrender provisions. And many of you are aware that certainly is something that's been required in law for a long time, but its implementation was never really standardized. And so Act 322 does create just that, a standardized procedure for the surrender of firearms for people who are, or respondents in domestic abuse, child abuse, or harassment injunctions. And for the harassment, obviously, or maybe not obviously, firearm surrender is not an automatic in harassment injunction, so for that particular restraining order, the court would have to make that specific finding. And there's also Act 323 that just has some miscellaneous restraining order provisions. It adds some increased privacy protections for child abuse injunction hearings by excluding persons who are not essential to the proceedings, limits access to records of those proceedings. It adds stalking or threatening to stalk to the domestic abuse definition. And now for harassment restraining orders, or TROs, and injunctions, which many sexual assault victims may have to use that harassment if their perpetrator was not an intimate partner or meeting the definition of that they were not fit under the domestic abuse restraining order. They will have to go use the harassment restraining order. That they can now ask the court to order the respondent to not contact the petitioner without that person's written consent. Previously, that restraining order really talked about ordering the respondent to cease or avoid harassing the petitioner. So now adding that no contact provision to that restraining order. And shifting gears, where I'm going to bring in our guest speaker, Sarah, regarding some of the changes related to reproductive health, specifically some of the changes related to abortion, some of the restrictions, quite frankly, on abortion in Wisconsin. And this is something that we saw happen early on, and with lightning speed, right? So I'll quickly just talk about what this statute or law does, and then I'm going to bring Sarah in to talk about their perspective, anything they're hearing about, sort of, or what the impact of this legislation.
Oh, I'm in.
Yeah, go.
Hi, everybody, and I'll be sure to introduce myself more and talk more when I'm officially in. This is one of those issues that was really quite a slap in the face to women in Wisconsin. It went so fast. It was introduced in lightning speed, as Ian was talking about. And we really reached out and immediately started working with groups like WCASA to recognize that this is a violation of women across the board, but especially those sexual assault victims who, because of this law, any woman would be forced to have an medically unnecessary transvaginal ultrasound before seeking an abortion. And so, as Ian and I were talking about before this webinar today, only 65% of women typically report a sexual assault. So for those women, you can be exempt from having a mandatory ultrasound prior to an abortion if you have reported and have documentation of a sexual assault. But for those women who have not reported and are seeking an abortion, it's that re-traumatization of women who, again, have not reported, have gone through the trauma of a sexual assault, are trying to seek an abortion from her attacker and are forced then to be re-traumatized with, and again, medically unnecessarily transvaginal ultrasound. And so, if you may have heard, this is a law that went fast. It was signed on the 5th of July, right around, right on the holiday weekend. It was really not one of those proud moments for this administration or the state legislature. And so we've been working hard to let women know that this happened at lightning speed against the consultation of the medical community and advocates like WCASA. And fortunately, part of this law, which includes requiring unnecessarily admitting privileges within 30 miles for the physicians performing the abortions at hospitals, that part is caught up in the courts right now, but it's still in play to have this mandatory, again, medically unnecessary ultrasound for women. And so this is definitely something that women's health advocates, groups like WCASA and other domestic violence and sexual assault, the community has really been frustrated. This is happening across the country, and that's where we're at right now. I have not heard a lot of anecdotal information. I know a lot of providers of abortion are definitely trying to work with the different women seeking this health care. And so unfortunately, it's in play.
Right.
It's law in Wisconsin, and again, I just emphasize this is completely medically unnecessary. And this is just another obstacle being put up for women to seek this kind of comprehensive reproductive health care.
Thanks, Sarah. And I echo everything you said, and certainly with respect to those ultrasound, I think it was touted as, oh, well, there are these exceptions for sexual assault, so, isn't that great? But when you really looked at the statute, you had to see that, well, that's true, but that's only for those who are reporting, which, again, as Sarah talked about, many and most, in fact, sexual assault victims don't report to law enforcement. So, if to have such a procedure, a medically unnecessary procedure, as Sarah described, for someone who hasn't reported to law enforcement, they may have to have that ultrasound, which could only serve to remind them of the trauma caused by the perpetrator. So I think, again, not good developments, and Sarah touched on the admitting procedures, which could really impact access to those services, being held up in the courts. And so right now these provisions on this slide are not in effect, but for sexual assault victims there, those who become pregnant as a result of rape, if clinics were to close, you're limiting options and facing limited resources to explore those options. And
we only have 4 abortion clinics available in the state right now, which is not nearly enough for our 72 counties. And so if that admitting privileges, we should be hearing soon from the courts about that decision. But yeah, you definitely risk closing some of those clinics and, again, reducing access to this very safe and comprehensive aspect of reproductive health care.
Right, and certainly that would be, we would not want to have the result being victims of sexual assault seeking unregulated and potentially unsafe abortions closer to their home because of that, the limited access, or deciding to forcing them to carry their perpetrator's child as a result of that. So some negative developments with respect to this past session for sure. And then the other thing I guess I would just note about this was we talked about the rapidity of which this happened, and then really commending those legislators who came out and talked about their own sexual assault victimizations and who had the courage to speak publicly about their experiences as survivors of sexual assault, and that was something that was fairly noteworthy as well. And lastly, with the session would be kind of everyone's favorite topic of legislation related to sexual assault would be provisions related to offenders. In legislative sessions, we always see a myriad of provisions, some of which are enacted, some of which aren't related to sex offenders. I think, well, we could probably spend the rest of the time talking about that, the political expediency of, being tough on sex offenders. Obviously, that's a positive thing, but we've seen some really sound provisions and others that maybe not as sound. I'm thinking of license plate proposals, and you may have heard of some of those in the past. But anyways, to cover some of the provisions related to sex offenders, one would be Act 84, which actually was a really well thought out, reasoned piece of legislation, and I don't say that just because I was on the committee, the study committee that was formed to look at that, which it was very nice of them to ask WCASA and myself to be part of that. But I will say, having never participated in such a thing, it really was a really deliberative and well thought out process, which is not always the case with all legislation, as we just saw. But with the commitment of sexually violent persons, you may hear that as Chapter 980. You may have heard that called Chapter 980 cases or Chapter 980 offenders. Those are the people who are deemed sexually violent persons by the court and who, after their sentence at Department of Corrections, may be transferred to the Department of Health Services and committed. It's actually a civil commitment until they are no longer meet the criteria as a sexually violent person. And so why this committee formed was due to some raising and some judges raising the issue that they were feeling like it seemed that it was easier for an offender to be discharged from commitment, meaning you go from commitment at Sandridge or some other facility where you're obviously under strict scrutiny, you're confined, to release to the community without any support, supervision, that it seemed to be easier to do that than to get supervised release, and that they were feeling like that didn't make a lot of sense, and maybe was not good for community safety, right? Offenders who are just not monitored are ones we would be concerned about. So this committee formed to look at that. And in fact, the result of that process was modifying the standard for a sexually violent person to obtain supervised release, not to make it necessarily easier, but just to make it clear that what the standard is, and to not make it so hard or impossible that really the choice for the court was basically dismissal or discharge before they would have the opportunity to maybe have that intermediate step of a supervised release where they are under very close scrutiny. And so that was the outcome of this process, and I think it's a nice piece of legislation. There's also efforts to look at sex offenders on schools, again, and I think obviously that there's some obvious reasons for that. But Act 88 talks about sex offenders, those on the registry, not being allowed to be on school premises unless that school has been notified of the specifics of the visit. You know, it would be the date, the time, the place, and that person's status as a registrant. There's some exceptions that would be in the law, you know, for elections, or if that if the offender has a child enrolled at school, or is him or herself enrolled as a student. And so in those situations, you know, there are some exceptions built in. If the offender has a child, they must still notify the school of their status as offender, or if they themselves are enrolled, that the supervising agency, which would often be DOC, the Department of Corrections, must work to ensure the safety of students attending the school with the offender. Changes related to the registry, Act 283, I'll just go through this pretty quickly so we can get to Sarah's portion of the presentation. Talks about changes to the sex offender registry. That registry, including that the information available to the public, includes now is to include any sex offense that's dismissed as part of a plea agreement, and any of the addresses at which the sex offender is or will be residing. And it also makes some changes to those offenders who are subject to a special bulletin notification, or SBN, which, you know, without getting too bogged down in those details, basically DOC in some cases has the discretion, in some cases must notify law enforcement when an offender is going to be released, and that this act contains some provisions about what information must be released to law enforcement, such as address changes, so that an offender who is subject to one of those notifications, law enforcement must be notified if there's a change of address of that offender. Again, similar notifications requirements are now contained if a sex offender in another state becomes a resident in Wisconsin, and that's Act 343. And finally, just some miscellaneous changes in the statutes of note. The definition of intoxicant in a sexual assault statute now includes the term or hazardous inhalant, and that is defined. You can look at the statute for that definition. And then there were some changes to the Wisconsin Military Code of Justice to more closely align the sexual assault definitions with the Uniform Code, which applies federally or more expansively to the military beyond Wisconsin, to sort of update and make more expansive the sexual assault definition. It was fairly archaic, the terms used in there, and so I think this is, again, a positive development. Looking forward to the next session, I think, not surprisingly, budget advocacy will be important, and looking at the SAVES program, the SAVES funding, and hopefully increasing the funding for that program is a priority. I talked about accompaniment, and that will be a priority of WCASA's going forward, and that's something that we're working on, and it will continue to work on, is seeing a data collection of something related to sexual assault in the criminal justice system. That I think that's something we can learn a lot from, and right now there's no sort of uniform place where sexual assault data is collected, and even some of the reports that were generated, some of the sexual assault in Wisconsin reports by the former Office of Justice Assistance. One is that we haven't seen reports in recent years, but really those were limited to law enforcement reports. So looking at data related to sexual assault on a more comprehensive level, that will be something WCASA will continue to be looking at. Really quickly, a couple Supreme Court cases from this year, both the Johnson and the Sarfraz decision. I may be getting that last name wrong. Johnson talked about access to privileged therapy records of a criminal defendant, and basically we're in a status quo position. Criminal defendants still have that ability to access those records, provided they meet the requisite showing. However, I would expect that this will be an issue that will continue to be litigated. And then one that a decision from just last month related to Rape Shield. It was really, I think, a good decision in reaffirming the Rape Shield statute, and that evidence of past sexual relationship between the victim and the defendant. In particular, that's what this case was talking about, that type of evidence is really inherently prejudicial and should not be admissible unless that evidence can be so important to really outweigh that inherent prejudicial effect of that type of evidence. So I think this was a decision reaffirming, underscoring, whatever word you want to use, strengthening the Rape Shield law in Wisconsin, which is a positive for victims who are thinking about or who are engaged with the criminal justice system. So without further ado, I'm going to turn it over to Sarah Finger, who's going to talk about the Ask, Learn, Vote campaign.
Thank you so much, Ian, and thank you to everyone at WCASA for inviting me to be a part of this webinar today. In just a second, we're going to be able to get a live, screen up of the website. But while that's happening, I do want to thank you all for taking interest in this particular webinar. I'm a self-proclaimed policy geek, and I know that there's quite a few of you on this webinar today that I know very well, and appreciate you taking the time. You do so much on your day-to-day lives to help in these areas of advancing women's health, safety, and economic security, and to be paying attention to the advocacy and policy side and those opportunities. I really appreciate you doing that because policy can either happen with us or to us, and what I'm about to introduce to you is one part of making sure that we're in the kitchen rather than on the menu. Our organization, the Wisconsin Alliance for Women's Health, I founded it 10 years ago. We were called upon back a decade ago to really set a new table and recognize that to advance women's health in Wisconsin, we really needed to look through the policy lens, look at the opportunity we had to state, federal, and workplace, school, et cetera, different policies, and to really help connect the dots between different aspects of women's health. We do no service to women by segmenting off and siloing off different aspects, and so we help connect the dots between violence against women and mental health and economic security and maternal child health, chronic disease, etc. So that's our organization, and for the last few years we've been doing work to engage women in elections. We really consider that there are 3 seasons in the state of Wisconsin in terms of policy. In the spirit of football season right now, I'll talk about them in terms of seasons. And Ian recognized that there's a budget season, there's a legislative season, and there's an election season. We're in election season, and yesterday was Wisconsin's primary election, which I hope you all voted. But now it's countdown until November 4th, which is the general election in Wisconsin. Our organization has been committed to not only encourage women to be exercising their civic responsibility to vote and show up at the polls, but to do so as informed and inspired to make a difference. So our Ask, Learn, Vote campaign has been around for a while, but this year we really invited in all of our partners, and WCASA is one of those strategic partners. We have over 22 organizations in the state who have signed on, and I will go ahead and show you how wonderfully diverse this group of supporters are. I just have to, I have to do my technology here, Ann. I just scroll down. Here we go. And so this is just a sample. This is a group, and there are groups being added by the day. But these are all organizations across the state that serve women and help advance the lives and health of women in the state, who recognize that the elections are a real key opportunity to make sure that what matters to us matters to our elected representatives. When it comes down to it, this is one of our finest opportunities to make sure that we know what we're ordering when we go into the polls, so that when we show up during the legislative season, that we're not just, blindsided by moves to not advance human trafficking or allow equal pay for women, or to make sure that we're providing medically accurate sex education in our schools. There's a lot happening around women's policies these days, and people tend to be surprised when their legislators are voting really out of sync with our needs and our values. And so this effort is really to, again, empower, and we love working with groups like WCASA because, for those unfortunate circumstances where women are often victimized and traumatized, this is a wonderful empowerment opportunity to kind of reclaim an opportunity to make sure their elected leaders are looking out for their needs as survivors, and to make sure there's prevention for other women in any of these cases. Again, I'm going to try and navigate around here. I think maybe because my screen is up, I can't do the scrolling button on the side. Maybe I need to minimize the side. But bottom line, the whole Ask, Learn, Vote concept, again, it's really emphasizing that not only should you show up to vote and know your rights as a voter and know, opportunities to early vote and what the requirements are to voting, but to ask and learn. Ask is a real important component. Again, go in eyes wide open to the polling booth. We have an opportunity to, now especially after last night, we've narrowed down the playing field. We now have only a handful of candidates who are running for different state offices, and so it's even easier to find out what your candidates feel about different issues that you care about. Our effort here lists different questions that you should be asking your candidates, and maybe you're not going to go to a candidate forum, or maybe you won't necessarily call up the candidate's campaign office directly, but even through social media you can start posing questions to the candidates running that will be working for you, and ask, up front, do they believe in paid sick leave? Do they believe in Medicaid, expanding Medicaid to cover more people in the state? Do they believe in SAVS funding? And again, we worked with a lot of their partners to identify those questions that should be asked up front, so that we know and can be an informed voter on November 4th and say, okay, this person reflects my needs and concerns, and what matters to me matters to them, and I'm very confident in voting for that individual. So yes, we challenge individuals to go ahead and ask those key questions so that we know ahead of time, again, what those candidates, how those candidates might actually vote on laws that were outlined by Ian today. The other aspect of this is learning. What's beautiful about incumbent candidates is that they have a voter record. And it's all public knowledge, but I think our Ask, Learn, Vote campaign takes a step further in organizing all of this information for you, for the public. And what we've done is actually taken by Senate district in the state of Wisconsin and tracked all the different laws and bills that were taken up this last legislative session, and show you where your legislator has weighed in. Those check marks mean that they took an affirmative position, whether they sponsored a bill, whether they actually voted on a bill. We did all that work for you so that it was very easy. We don't want any barriers to come up for you to be intimidated by the voting process, to go into the voting booth and say, I just didn't know enough about my candidates or about my legislators. And maybe there's a legislator that's retiring and it's an open seat, but you can go in and do the same exercise and look and say, well, even though that legislator was retiring, they weren't really good on issues that mattered to me. Here's an opportunity to put a candidate in that office that will reflect my values and my needs as a voter and as a constituent. So that's the kind of work that we have done with this website to just organize it by district. And we even have, all sorts of quick links that allow you to look up who your state legislator is, know which district you live in. We're really, again, trying to bring advocacy opportunities to everyday people who may not be, a self-proclaimed policy geek like myself who has their state assembly person and state senator programmed into their cell phone. But this is very doable, and we'll always take feedback from any of you who are looking for easier ways to make this a very effective empowerment and educational tool. And then obviously voting. Again, we have a countdown going on now, November 4th. Everybody mark your calendars. There's going to be early voting opportunities, whether in person at your polling or at your municipal clerk's office or absentee ballot. There's no excuse. There's all sorts of ways. Wisconsin's actually lucky that we have same-day voter registration. So not only you as advocates, I'm going to make an assumption that most of you are voters anyways, but it's a midterm election. It's non-presidential. People tend to stay home. We can't afford to do that these days. So not only you as advocates, you need to show up on November 4th or, ahead of time with absentee voting or early voting, but all the different women that you work with. This is such an amazing empowerment and powerful tool, and it's our right. And we have an incredible opportunity to, again, make sure that what matters to us matters to our elected representatives. So there's information here about, again, you don't need to show voter ID, even there's a lot of confusion about that. There's clarification there. Clarification about what your rights as a voter are. You can print this off and know that if you're standing in line at 8 p.m. At the polls, like if you were last night, they can't turn you away. So this is the kind of, again, hopefully one-stop shop that we've put together that will really help give the tools necessary for people to not make any excuses and to use this great opportunity during this, one of the 3 very important advocacy seasons in the state of Wisconsin. One thing I just will point out, we are really encouraging people to pledge. Make sure that you sign up and stay connected, because by pledging and signing up for these kind of communications from this campaign, we will be alerting you when absentee ballot opportunities come up and early voting and rules about, again, not showing up with political T-shirts on election day or not taking pictures of your ballot because that's illegal. We're going to help guide people through this process. So we have a big push for pledges right now, and hope that you will encourage and maybe post to your social media networks, through your friends, and encourage people to pledge to vote through the site. And just to also, again, we want to make people excited about this. So just know that we have swag available, and by all means, let's be proud about this amazing opportunity we have to make sure, again, that policy happens with us rather than to us. I don't know if you wanted anything else, Ian, or what else. I just really wanted to appreciate the opportunity to introduce this campaign and let people know that, again, there's 3 absolutely critical seasons in the state of Wisconsin, and we are neck deep. And so while we're cheering on the Packers and going football season, let's make sure to embrace the election season. And I know my contact information isn't up here, but it is. Yay, it's in the chat. That's what the message. So by all means, if anybody wants to get involved, wants more information, I'd be happy to answer any questions. And again, appreciate this opportunity.
Great. Thank you, Sarah. Really appreciate hearing about this campaign, and I think there's a lot of fantastic information on that website, so please, hope you all take a look at that. I certainly plan on doing that. And thank you again to Sarah and the Alliance for being part of this webinar. I guess at this point we could see if there are any questions that people have, and we'd be happy to answer those. If folks want to chime in via chat, that would be fine. And Rose is asking, do we know anything about the day formerly known as Lobby Day? We don't call it Lobby Day anymore. What are we, Advocacy Day, or I forget. It's a great question. Thank you, Rose, for asking it. We do not have a date yet, but we usually do that every 2 years, and do that around the beginning of the legislative session. So we would be 2015 would be the date when we would be having our Advocacy Day. We do that, have done that with NWS Wisconsin in the past. So it's on my radar screen, and Tony and I will be talking about getting a date out, and as soon as that happens, we will send a save the date out about Legislative Advocacy Day. Thank you, Rose, for asking about that.
It seems like there's some comments about fading, but there was also a comment about seeing the partners, I believe, on the act.learn.vote site. So we just went ahead and put that out there. And I don't think I even said it's simply act.learn.vote.org. So you can also visit the site yourself and play around and look at our different options that we have.
Okay, there is a question. Because of the expanded definition of commercial sex act, it seems like it may even be able to be applied to strip clubs, etc. Well, that's a great question, and it requires me to get my definition of commercial sex act, so bear with me. Yes, the definition. Actually, Peter, is there a way we could pull up that definition on the line so we could all look at it? That might be actually a useful use of our technology rather than me reading it. Let's be visual here. And so why don't just bear with me. We're going to pull up that definition. Just one second.
I feel like this is an exercise in Google. I do. We feel like we have a tutorial. Look up the act. Under the tulips.
Statute. Thank you, Rose.
Feel free if there's any other questions too to go ahead and post them while we're pulling this up. You know, Rose is asking me if I had any reflections on voting yesterday. I think they were kind of surprised at some of the turnout. Pleasantly surprised. I know Milwaukee had a good turnout. It's definitely, I think it's earlier this year too. We usually have a primary in September. So having in August, I think that kind of caught people off guard. It's a big vacation week. And so, yeah, so but through our website and through others, we'll definitely be sharing the candidates who won. And Ian and I were talking about, you know, we'll definitely have to be reaching out to the two candidates now who are in the race for Attorney General. That's going to be a very important seat in terms of sexual assault.
Indeed. Okay, so the question about Commercial Sex Act on your screen, I believe you can see the highlighted text. Yes, I can see it twice, which is even better than once. There's the definition. And so what it used to say is Commercial Sex Act means sexual contact for which anything of value is given to, promise, etc. And so now you can see that it includes sexual contact, intercourse, and sexually explicit performance or any other conduct. So I think, you know, your question about it being applicable to strip clubs, potentially, I think that's true. Because remember, in addition to those contact, intercourse, performance, again, anything of value has to be given to, promise, or received directly or indirectly by any person. So I think if the question is, does that include strip clubs, I think, you know, that, remember, this is just a piece of it. You would also have to have, could someone be trafficked in a strip club? Absolutely. Provided they were, you know, if you look down here, recruited, I'm pointing as if you can see that. I'll use my cursor. If that person was recruited for the purposes of a sexual, commercial sex act, and that was done by any of the following, causing or threatening to cause bodily harm, or the last one, remember, causing or threatening to cause any individual to do any act against the individual's will. So trafficking someone by forcing them to perform in a strip club, I think, yes, arguably you could make that fit under the human trafficking definition. That's the off the top of my head answer.
Ian, will you be putting forth a policy agenda then for next year? You said like a formal?
Yeah, we will. Yes, we will. I imagine that would be, usually comes out at the end of the year. So yes, you can look forward to WCASA releasing that.
Yeah, we got to be ready for January.
Yep.
A lot of new legislators and a lot of opportunities for all of us to be making those relationships with a lot of freshman legislators
Absolutely.
who can be educated on why any number of these issues are important for them to pay attention to.
Absolutely. That's a great point, Sarah. Well, if there are not other questions, I think then we will bring this webinar to a close. I see we're also reaching the end of our time as well. So you can certainly, my contact information, Peter can send out. Some of you may have that anyways, but you feel free to email me. You have Sarah's contact information as well. Peter posted that via chat, so we are certainly available for questions offline after the webinar if things come up. But if there's nothing else, then I just want to thank all of you for participating. I want to thank Sarah for joining us today. And I hope you have a good rest of your day, and we'll look forward to the next webinar in October at some point. October 8th at 10 a.m., the next webinar. And that will be the All Committee. They will be sponsoring that. So stay tuned for more information about that. But the next webinar, October 10th. 8th. Sorry, I knew there was a 10 in there somewhere. It starts at 10. October 8th, 2014 at 10 a.m. Thank you all so much, and have a great day.